Why liquidate if strike-off is cheaper? Well, there's a good reason for this, because strike-off is a procedure that requires absolute strict compliance with the rules. That's not to say that liquidation doesn't require strict compliance with the rules, but the rules are very, very different indeed. If you are going to strike off a company, you have to give notice of the DSO1 form, which is the strike-off form, to creditors. As soon as they receive that form, then potentially they can object. That objection process can take months and in some cases years, depending on who the creditor or the creditors happens to be. If your creditors are HMRC, for example, that process can be renewed over a period of time. Same goes for if you've got a bounce back loan. Again, the objection can be renewed repeatedly over a period of time. We've seen many instances where companies have got bounce back loans and essentially the strike-off procedure has been suspended for, in some cases, years, literally. So during that period, the company will still need to file accounts, the statutory annual accounts. It will still need to file a confirmation statement, and you'll still need to file a corporation tax return. Now, those documents may be relatively straightforward if the company's not trading, but they nevertheless need doing as a matter of compliance. Otherwise, there's a risk of essentially criminal offences being committed for failure to file particularly accounts and a confirmation statement at Companies House. The alternative, of course, where there is less restriction, is liquidation. Whilst you need a resolution, 75% of shareholders and things like that. In the case of an owner-managed business, it's usually not a problem if all the directors and shareholders are singing from the same hymn sheet. So the restriction and the ability for creditors to intervene and object to a company going to liquidation is basically non-existent. The only thing that a creditor could do is, if the company was still trading, for instance, it's possible in an extreme type of case, but it's extremely rare for a creditor to petition the court for the company to go into administration. But it's so rare that it's not really worth considering in any great detail. Ultimately, creditors cannot really object to a company going into liquidation, but they can object to a company being struck off. So although strike-off may appear to be slightly cheaper, to begin with at least, it is not necessarily a superior and preferable procedure to that of liquidation. Questions, queries, concerns, give us a shout. Winner Insolvency, Inside Out.